Good morning, ladies and gentlemen. It's a great pleasure and absolute honor to welcome you to the second day of our conference, Human-Centric AI, Ethics, Regulation, and Safety. This is an annual conference organized by Vilnius University Faculty of Law. Today gather prominent speakers in this field, AI field. Before we begin, I would like to provide some useful information. On the reverse side of your badge, you can see a QR code. You can scan it and have a full program in your phone. Today we will have 3 sessions. We are starting at about 9:30, I guess, with the first panel, Legal Foundation for AI and Human Rights, moderated by Professor and our Vice Dean, Jurgita Paužaitė-Kulvinskienė. At about 11:30, the second panel on legal challenges of AI in technological innovation, moderated by Professor and a judge from the Supreme Court, Egidija Tamošiūnienė. And due to force majeure, 2 speakers are not coming, so we have a little bit space for discussions. So we will a little bit deviate from our schedule. From 1 to 2, we will have lunch. And the third panel will start at 2 o'clock. It's about AI regulation, consumer protection, and data security. And the moderator will be Associate Professor Albertas Šekštelo. And now I would like to invite Law Faculty Dean, Associate Professor Haroldas Šinkūnas for the welcome speech. Please.
Good morning, dear colleagues. Labas rytas, mėly kolegos. I hope, and I saw a bit, that yesterday was very insightful, very interesting, and so we may start in the second day, which will be, I think, not less interesting, insightful, and challenging, maybe. So I have the formal speech, so let me say what is written here on my iPad, because my AI is not so good. Distinguished guests, esteemed researchers, dear students, ypač sveikinu mūsų studentus, kurie čia dalyvauja ir kurie šitą temą domisi. Ladies and gentlemen, I'm the second time greeting this conference. It's not written here such-wise, but it's a great honor and privilege for me to welcome all of you on the second day of the international conference, which is called Human-Centric AI. I don't know if it's possible, actually, but the name of the conference is Human-Centric AI, Ethics, Regulation, and Safety. Organized by, of course, by the law faculty of Vilnius University. As you continue your discussions today, you do so with a shared mission to explore the ethical, legal, and safety challenges posed by artificial intelligence and, most importantly, to seek solutions that ensure these technologies serve humanity, not save, but serve humanity and society. For centuries, Vilnius University and our faculty, for instance, have stood at the crossroads of pivotal moments in history, acting as a hub of scholarly thought and societal progress. From our founding, we have been part of debates and developments that have shaped not only the legal system, but also the society. Today, we also face the challenges brought by the rapid development of artificial intelligence. As we look at the present, it's clear that the challenges of AI cannot be met by the legal profession only. This is why we are particularly proud of the interdisciplinary and international nature of this conference. Whether in the field of law, healthcare, or social services, AI opens new frontiers. But it also raises serious questions around ethics, safety, and human rights. In this context, our faculties here not only deepening research into these issues, but also fostering the dialogue across different fields of science, recognizing that no single field holds all the answers. As we look ahead to the future, I am filled with optimism about what you will achieve after all discussions in this conference. May the exchanges of ideas we share in this conference inspire new thinking and innovative solutions that will help ensure that AI develops in a way that protect and promote human values and societal well-being. Let us live here with a renewed sense of purpose to ensure that as we regulate AI and harness its power, we always remain centered on the human element. That we create frameworks that protect rights, ensure transparency, and build trust in a world where machines and algorithms increasingly shape our lives. Together, let us not only embrace the technological advancements of today, but also guide them with ethical clarity, legal vision, and a commitment to safety for all. Thank you for being part of this vital conversation. Thank you for coming to Vilnius. Thank you for being with us. And I look forward to the insights we will gain from these discussions. And finally, of course, I must do that. I wish you an enjoyable time, not only at this conference, but also in our city, Vilnius. It's not so warm today, but still it's spring. So the nature is very beautiful right now. So you have a nice day. You have very interesting discussions. And thank you for being here. Thank you very much.
Thank you, Dean, for the inspiring talk. And now I would like to invite our Vice Dean, Jurgita Paužaitė-Kulvinskienė, to moderate this panel. Please.
I can take the seats here?
Yes.
Yes, good morning. No, this is better? No. Yeah. Good morning, everybody. Once again, so we will have very intensive day. The sun is shining, but not for us in the morning, perhaps in the afternoon. We will join our nice city and our university and the law faculty. We really all are very glad to have you here and to connect all of you on this challenging topic, technologies in law or law for technologies. I don't know how it's better to explain. I will moderate the first panel. So yesterday we started already with introductory questions like ethics, regulation, and we started with legal challenges already. Today we will continue and we will speak and discuss more details about legal foundations, about legal grounds on European level, on national level, based on different legal acts like IE Act or directives or GDPR or IE Liability Directive, and etc. And we will navigate from European level to national level. We will navigate through public law and private law. We will take a look of the influence of IE to human rights. Of course, it will stay our main focus. And I'm very glad to pronounce you that we are different speakers from different countries, from Poland, from France, from Latvia, from Belgium, and from Great Britain, and etc. And I will start now with the first presentation from our neighbor countries, from our nice colleague and Irena Barkane. It is a researcher at the University of Latvia. She deals with technologies law. She deals with criminal law as well, as an institute, more criminal procedure law. But she will give us a look, an explanation, an overview of EU regulation, more of EU basis concerning the Artificial Intelligence Act. And she will try to find a balance between innovation and regulation. So, Irena, the floor is yours. If you need slides, you have already.
Yeah.
Okay.
Thank you so much. Good morning, ladies and gentlemen, dear colleagues. It's my great pleasure to be with you today and to participate in this conference devoted to regulatory and ethical challenges of AI. Thank you. I would also like to thank colleagues at University of Vilnius for organizing such an excellent event. And one of the greatest challenges related to AI regulation across the world is how to find a right balance between regulation for trustworthy AI and innovation. And in my presentation today, I would like to discuss how the EU AI Act seeks to balance innovation and regulation. As we all already know, AI Act has entered into force on 1st of August this year, and it will become directly applicable in all EU member states after 2 years, but there are some exceptions. For example, prohibitions will apply already after 6 months, and also rules governing general purpose AI systems will apply in 1 year. And this transition period is given for companies, institutions, organizations to prepare for those new requirements, as well for supervisory authorities to prepare for these new rules. There have been already important steps taken to prepare for those requirements. A few days ago, over 100 companies signed up to the AI Act voluntary commitment to start apply those part of those new rules already earlier. The so-called AI Pact initiated by the Commission to bridge is initiated by the European Commission to bridge the gap between this law and its operationalism. The Commission also is taking action to boost EU innovation in AI, and on 10th of September, the Commission has launched a call for setting up AI factories, which will bring together the key ingredients for AI innovation, such as data, computing power, and talent, and those will be available to startups, industry, and researchers. Those two actions are well in line with two objectives of the AI Act, and this AI Act aims on the one hand, to improve the functioning of the internal market, promote the uptake of human-centric and trustworthy AI, and support innovation. And on the other hand, it tries to ensure a high level of protection of health, safety, fundamental rights enshrined in EU Charter of Fundamental Rights. And so the question is how these two objectives are interconnected. Professor Giovanni Sartor already some years ago has emphasized that these two objectives are distinct. The most advanced AI systems can pose serious threats to citizens' rights and values. Likewise, effective protection against the risks posed by AI systems does not in itself provide the incentives that are needed to promote the uptake of AI. At the same time, these two objectives are also compatible, and the question is how to effectively implement the new rules by taking account of both objectives. So, AI Act aims to introduce a balanced and proportionate horizontal regulatory approach with a view to achieve both objectives. It introduces prohibitions of certain AI practices which contradict to fundamental rights and values. It lays down specific rules also for high-risk AI systems, providing obligations for operators of such systems. The AI Act also sets up specific transparency rules for certain AI systems. Also, it provides rules for place on the market of general-purpose AI systems, rules for market monitoring and enforcement, and also measures to support innovation with a particular focus on startups and small companies. The AI Act follows a risk-based approach and classifies all AI systems based on different risk levels. They create from unacceptable risk, also high-risk systems, then systems who raise transparency risk, and there is no specific regulation for those systems creating minimal risks. While this AI Act follows a risk-based approach, it is grounded in fundamental rights enshrined in this EU Charter on Fundamental Rights, which plays crucial role also in classification of AI systems. At the same time, we should also remember that there has been a critique from civil society, in particular regarding those prohibitions, stating that the EU AI Act fails to fully protect fundamental rights. The extent to adverse impact created by AI systems on fundamental rights is also of particular relevance when classifying AI systems as high risk. AI systems can be classified as high risks in two cases. First, if they are intended to be used as safety component in products, or if these systems are itself a product covered by EU harmonized legislation listed in Annex 1, or systems who are used in the sensitive areas listed in Annex 3, which lists eight high-risk use cases, starting from biometric, education, employment, law enforcement, migration. I'm sure you heard about them already yesterday, so I will just go very fast about those requirements. The AI Act sets a wide range of requirements for high-risk AI systems, starting from risk management, the quality of data sets, technical documentation, transparency, human oversight, accuracy, cybersecurity, and providers of high-risk AI systems must also conduct conformity assessment prior to the placement on the market or putting into service of these systems. What measures do the AI Act introduce to support innovation? The AI Act enables creation of regulatory sandboxes and also real-world testing. Regulatory sandboxes is one of the primary measures provided in the AI Act in support of innovation. It is a tool allowing businesses to explain and experiment with new and innovative products, services under regulators' supervision. There is a very long and complicated road ahead to make these new rules effective in practice. And it also requires effective enforcement mechanism. Within 1 year, countries must designate responsible supervisory authorities. The AI Act also created European AI Board, a key advisory body which consists of representatives of each member state. And regarding general purpose AI systems, they will be governed at EU level. AI Office, the Center of AI Expertise across the EU, has been established by the European Commission, and it has initiated also drafting of code of practice for the providers of general purpose AI models. There has been already negotiations has started, and it is of utmost importance that these supervisory authorities, both at EU and national level, promote understanding and provide guidance to private companies, state institutions, and other stakeholders on how to comply and implement these new requirements introduced by the AI Act. It is also important to explain the interaction between the AI Act and the data protection rules. For example, regarding fundamental rights impact assessment, how it must be conducted, provide some templates or guidance, and how it is connected, linked with already the other mechanisms, data protection impact assessment, which is provided by the General Data Protection Regulation. If you look what has already been done, some institutions have already prepared some guidance. For example, Belgian Data Protection Authority has published a document about artificial intelligence systems and GDPR. Also, Dutch Data Protection Authority publishes reports twice a year on AI risks, and also provides information for companies what they need to do to comply with those requirements. Also, if you look, ECO has provided guidance regarding accountable AI accountability. It should be noted the data protection rules haven't lost their importance due to the AI Act, but quite the contrary. Last month, Meta, with more than 50 other organizations, published open a letter calling EU to address controversial AI rules. It points out that Europe is lagging behind other regions in AI development. This letter calls for clearer and faster guidance on artificial intelligence, particularly on what data can be used to train AI models. These companies are concerned that the intervention of European data protection authorities could hinder the use of European data in artificial intelligence training, thus limiting Europe's competitiveness. And so those inconsistent AI rules in the EU, which are causing concerns for many companies developing those AI models, are the GDPR and data protection authorities, which enforce them. And Europe should have been worrying if there would not be such a reaction and such open letter from US companies, which proves that probably EU is doing something correctly to stop data colonism of big tech and private interests. Recently, Anu Bradford, a professor of Columbia Law School, published a paper arguing that there is a false choice between digital regulation and innovation. She points out that a common view advocated by the tech industry that more strongest regulation of the digital economy inevitably compromises innovation and undermines technological progress is not correct. The relationship between digital regulation and technological progress is more complex. This existing technological gap between the US and EU is caused by various others more foundational factors. For example, one of the key barriers to innovation in EU is the fragmentation of fragmented digital single market that limits the scaling of innovation within the EU. To conclude, there are three equally important questions which needs to be answered. First is how to promote innovation. While US companies want to extend its market in EU, the EU itself is lagging far behind. While the US companies has developed new innovative technologies and investment has followed redirecting resources to sectors with high potential for productivity growth, Europe has weak position in digital technologies due to low investment and low innovation. It is crucial that Europe invest in its own technologies and AI development. The second question is how to overcome the regulatory barriers for tech companies. One of the key barriers to innovation is the legal barriers which should be avoided. The EU now has around 100 technology-focused laws and more than 270 regulators working on digital networks across all member states. And regarding AI Act, it is crucial to help companies to navigate through these new requirements and not reducing those regulatory barriers. And the third questions which is also equally important, is how to ensure that AI is trustworthy. It is it's important to promote the development and uptake of human-centric and trustworthy AI, and to address those risks AI systems raise to fundamental rights and our social values. Thank you all for your attention. I'm looking forward to our further discussion. Thank you so much.
Thank you very much. Thank you very much, Irena, for indeed interesting presentation and for your questions for discussion. I hope all three questions could be delivered for the audience as well, because they are so basic and so general when we are speaking about the tech industry and the legal regulation. How deep need to be the legal regulation for this kind of industry? We can ask the same question related to another industries, like energy industry or cosmetic production energy. How deep need the law regulate such a sector? So thank you very much, Irena. Thank you very much. And I would like to invite two next speakers. It is a team from Poland, from Kosminski University, Mr. Roman Bieda and Ms. Anna Bednarek. Yes. Both of them are representing academia as a private sector as well, because Roman Bieda, he's the founder of AI Law Tech Foundation. It is a public agency which deals with interdisciplinary think tank on the technical, legal, ethical, and businesses aspects of concerning the development of new technologies, digital economy, and information society. He's a director of legal law programs and he teaches at Kosminski University in Warsaw, and takes part on two very important experts group. He's a member of expert group under the Polish Data Protection Authority, and another working group on ethical and legal aspects on artificial intelligence under the Ministry of Digital Affairs of Poland. Anna, she's from Łódź. Łódź, yes, as understood, our good friends. We have very close cooperation with Łódź University, starting many years ago. And she is focusing on commercial law, on corporate and new technologies law. She works at the legal clinic of the university on Łódź and law firms. And I would like to present and to announce the topic of your presentation. Sorry for the some difficulties for me. So law challenges is quite clear, but law challenges of quantum AI systems, so some physicians aspects will be in your presentation. So please.
Do you hear me without microphone?
You can use mine.
Okay, thank you very much. Thank you for having us here, for invitation, for invite us here, and to allow us speak to you today. Professor said everything about us, so I think that it really is not necessary to repeat. Yes. And what we would like to do today. First of all, I would like to explain in few words the idea of quantum AI, idea of quantum physics in 1 minute. And next, we will focus on some legal challenges of quantum AI. So first issue, what is a quantum AI? Quantum AI is a machine learning algorithms, AI systems supported by quantum computer. It means that we use a quantum computer to teach, to use an AI system. We use a different algorithm, special algorithm for quantum computer. And for this reason, this new AI system will have a very huge capability, very huge new possibility of working, of power. And we, first of all, we come back to the school. We are not physicians, we are lawyers, so it will be only a big picture, and I hope that there is no lawyer on this room. No, sorry, no physicians of this room, sorry. But I will try to explain in a few words. I think that everyone knows this graph from the preliminary school. It is a car. We have a time. We have a direction, the way, direction. We have a time, and we have a speed, to be honest, the momentum, not the speed, momentum. And in this case, we know where is the car. We know that after the 10 minutes we'll be here, for example, 1 hour we'll be in Kraków or in Warsaw in Poland. And in this, it is easy. It's a classical mechanic. It's a Newton mechanic. Everyone understands it. But quantum physics is completely different. It's a phenomena, it's a new phenomena, it's a completely different. And in this, the quantum means the smaller amount of something, especially in energy. Quantum physics works on a micro world. And can you imagine that you have a quantum car? It means a very, very, very small car, like a photon. And in this case, we cannot define where is the car. We cannot define where is the position of the car. We can say that the car is in some positions on the way with some probability. With some probabilities here, maybe here, maybe here. We don't know where. Maybe you know from the secondary school Heisenberg rules. The Heisenberg is one of the a father of quantum physics. And he said it is impossible to define in the same precision a momentum and the position. And because we can find the photon, we can find, in our case, the micro car, in some places with some probability. So one of other father of quantum technology, quantum physics, Richard Feynman, he was in Warsaw and playing on the drums, and he was of course a Nobel Prize winner. And he said that I think I can safely say that nobody understands quantum mechanics. So if nobody understands, we can understand a little only. So, as I said, the quantum AI is a quantum system supported by quantum computer. So we can ask, what is the difference between the classical computer and quantum one? If you have a classical computer, I think that everyone knows about it, the classical computer uses bit. Bits can be in one state, 0 or 1. It means that is a 0 and 1, spin up, spin down, energy on, energy off. Yes, it's only 2 positions. In the case of the quantum, we use qubits. Qubits is a quantum bit, and qubits can be in the different states in the same time with some probability. It means that in the same time can be a 1, can be a 0, and everything between 1 and 0 is some probability, like this car on the first graph. It means that qubit is in the superposition. We call it the state superposition. For this way, the computer can calculate very fast, can work very, very fast, because they work on different possibilities in the same time. Not only 1, 0, 1, 0, only a lot of different possibilities. And it gives the quantum computer extraordinary power. And what is interesting? When you have a normal classical computer and you add another bit, the power of the computer increases linearly. Yes, binary. In the case of the quantum computer, you can imagine, in 2019, Google launched a computer with 52 qubits. After the few years, they launched another computer with 70 qubits. It means that it's an 18 qubits difference. What do you think? How biggest is the second one? What's the difference of possibility, of power? 2 times, 100, 1,000? What do you think? No idea. 241 millions is more powerful, the second one, than the first one. It's only 18 qubits difference. And I found a few days ago that IBM last year launched a computer, a chip Condor with 1,000 qubits. 1,000. It's, of course, they change idea. Now they produce a smaller one, but it's from different reasons. It's a problem with errors, etc., etc. So it will have a huge amount. Huge amount. So this kind of new computers connected with AI will be able to compute in very fast way a huge data sets, to find a different relation between data, different predictions. For this reason, is a danger for our human rights, privacy, because it will be possible to find connections between data which are not possible to find in classical computer. But it's not a problem of speed only. It's not only a problem of the speed. Speed is one issue. But second, maybe the most important, is that the quantum AI will use a different algorithm which are impossible to use on the classical computer. It will be works in different way. And for this reason, it will be possible to find different connections with different patterns, with different relations, which we can't find now on classical computer. For this reason, it will creates a huge risk for our privacy, human rights, data protection, etc., etc. And cybersecurity, but it is a different topic. It will be an AI system on steroid.
Okay, so quantum AI systems will have great impact on all industries and all sectors. So actually, how these quantum AI systems can be used? For example, in finances, quantum AI systems can improve financial modeling by preparing greater and faster simulations for risk analysis and fraud detection. For example, in healthcare, quantum AI systems can improve medical diagnosis, drug discovery, and personalized treatments by analyzing massive patient data and biological informations. And in logistics, quantum AI systems can improve route planning and supply chain management.
Okay, so a few legal challenges of AI systems. First of all, the question is, maybe you know that quantum computers are very expensive. For example, a few years ago, D-Wave 2000 cost some $15 million. And it is impossible that a middle-sized company or startup will buy this computer by themselves. It's too expensive. And another issue is that these computers are produced only by a few companies from USA, Canada, and China, generally speaking. So it is a high risk of monopolization of the market of quantum computers and in next step of the AI systems. So the question is how to provide access to these quantum computers in democratic way is a legal challenge, it's a huge legal challenge. And to resolve this problem, European Union decided to build European quantum computer and provide this computer for startups especially. And the first step was established a joint undertaking. Joint undertaking is a partnership, is a platform of cooperation between national countries and business and private sector, etc. It has a legal entity, and the main aim is to develop European supercomputer infrastructure. It means also quantum computers, and this regulation stipulates the rules of acquisition of quantum computers and sharing the quantum computers between the states, between the partners. And in next step, European Parliament enact decision, and according to this decision, by 2025, Europeans should have the first computer with quantum acceleration, and in 2030, European Union should be a cutting edge of quantum capability. So we have a plan. And in next step, I'm very happy that joint undertaking have chosen 6 countries which will host and operate the first European quantum computer. And Poland is one of country which will host a first European quantum computer. We are building this computer in Poznań, in Poland. And according to Polish government, it should be ready to the end of next year. So, but it's a difference. I don't want to elaborate this topic. It's a huge political discussion, and I discussed this issue with Polish Minister of Digital Affairs, and I try to stress him, we have to prepare the Polish AI strategy, no AI prepared, quantum strategy, etc. What is the politics? I will not discuss this issue. So, we are waiting for the first European quantum computers. And in next step, European Commission announced that we will open our high-performance computers for startup. High-performance computers means also the quantum computers for startup, which are ethical and responsible. In next step, European Council amend the joint undertaking regulation, and according to this amendment, joint undertaking have to establish AI factory. AI factory is an entity which will provide access for high-scale computers, especially quantum computers, for a European startup. So we did this next state. Of course, it's also a possibility that we will use a competition law to protect our market. Is another possibility. I have another idea. As you know, according to AI Act, each country should set up a regulatory sandbox. Of course, also the European Commission and also the Data Protection Supervisory will establish own regulatory sandbox. And European Commission will enact the special delegated act, which will stipulate the rules of the regulatory sandbox. And maybe it is a good place to establish rules of access of European quantum computer. Maybe in this delegated act or this national act, because each country have to implement all national act about their sandbox, we should establish the rule of access. It is another possibility in my opinion. And the next challenge, as I said, quantum computer works very powerfully, can compute a huge amount of data in very fast way, and will be able to find different patterns, etc. So the risk of violation of our human rights privacy is very high. And you know, Irena said about it, that AI Act focus on AI systems. And we have a list of AI systems in appendix number 3. And according to article number 7, European Commission can update this list, can add some another systems, I know, but how to use some sector to this appendix. And article number 7 stipulate the criteria which European Commission have to take into consideration when they change when they update the list of high-risk AI systems. And maybe, in my opinion, in the future, we should change the article number 7 and put another criterion. It means that if you use a quantum computer to this AI system, it is another criterion which have to be taken into consideration when the European Commission will decide about it, this system is on list or not. Maybe it is a good idea because these new systems will create a higher risk than standard system. And another issue?
Yeah, energy issue. As you all know, like typical supercomputers consume a lot of energy. As you can see, for example, ChatGPT consumes for each query as much energy as over 1,000 US households consume per year, and as much as a 5 watt LED bulbs for 1 hour and 20 minutes. It's a lot of energy. Next.
Oh, sorry.
Okay. So, on the other hand, according to European Declaration on Digital Rights and Principles for the Digital Decade, the principles of Europe are to support development and use of technologies that have minimal negative environmental and social impact, and to promote the development and use of innovative technologies with a positive impact on environment and climate. So, in the light of these principles, arises the question, is the quantum computer more energy efficient than a classical supercomputer? To answer to that question, we have to first concentrate on the quantum computer construction. As you can see, quantum computer can only work in absolute zero conditions. It means that in functions when the temperature is minus 269 Celsius degrees. It is as cold as, it is 200 times colder than in interstellar space. Now on this slide, you can see how quantum computer looks like. At the back of the, you can say, computer, you can see like huge refrigerator that lower the temperature of it to minus 269 degrees Celsius degrees. Yeah. Okay. So now, scientists say that if this quantum computer achieves the absolute zero conditions, it means that it is more, it's 10 times more efficient than a classical computer, and 10 times more energy efficient than classical supercomputers. So in the future, it's highly possible that this, we can say, quantum computers will be even more energy efficient, and that means that governments probably will take legislative actions to support development of these quantum computers and use of them by scientists, companies, and people.
Yeah, I would like to add only that it is not sure. It is only a research that maybe it will be 10 to 100 more energy efficient than classical one. Of course, other scientists say, no, it's not true. So we don't know yet. But if it is true, maybe in the future will be like in electric cars. If you have electric cars, you can go to the center. If not, you can't. It will be the same, I think. So that in the same usage, we will say, no, you don't. You shouldn't use a classical one because it's a more energy efficient. It's dangerous for our environment. So it was only a few challenges. These challenges are really a lot. We present today only a few of them. Thank you very much, Thanks.
Thank you very much.
Thank you very much. I saw we have already a question for
Yeah.
I don't know if we will have a time for discussion, but I am as a moderator. I can allow you to ask a question, of course, to have it.
Thank you so much for your illuminating presentation. I have a question about the tension between some of these fundamental rights that we're talking about, and how do we give proper guidance to businesses on which one to prioritize. For example, if you are faced with a privacy challenge, and I don't know, in France there is a proposal that every time there's a data deletion request by a person, the model has to be retrained, which you can imagine will take a lot of energy, especially if every one of us tries to delete their data. So if we have to balance, for example, between the privacy and sustainability requirements of this situation, how do businesses make a choice of what to do, and which comes first? So I don't know if this is a question you can answer. I know that the energy efficiency point at the end potentially can push towards that, but if we're talking about the overarching human centricity of these technologies, there's a lot of tensions that exist between these rights and principles that we're talking about.
Thank you. You want?
I don't know if I understand you. Maybe we discuss this during the break, because it's a huge topic. It is a really huge topic in this sense that I understand that business have a different point of view, and I was in Brussels during the working on the AI Act. I have seen it in the short distance, and in my opinion, it is not a legal issue. Unfortunately, it's not a legal issue, it's a political issue. And we know how to resolve the problems, but we are waiting for the political consent, and it is a problem, I think so. I'm very diplomatic.
Thank you very much for such a short remark. I suppose we have a topic for next conference, for next year. Technology law and link with sustainable development. But today we will stay on our main question about AI Act, and next year we'll move to the sustainable development. Thank you very much for the team from Poland, and now I would like to invite a team from United Kingdom representing the public agency Clever Together Democracy, the managing director Lydia Velkova, and Leda Valeria Kuneva. She's working at the same agency as an analyst and research and project manager. I would like to announce very shortly about the main task of this agency. It is a team of lawyers, of other professors trying to and focusing and exploring impact on social issues for private market, helping developing strategies and different issues on management questions. And as I understood, it is a big support for the business opportunities and for society, developing some democratic tasks on strategic projects. I know that we'll have very interesting presentation. Shortly, the team a little bit changed the topic, and shortly it could be announced the topic of the presentation: collaborative AI governance for tomorrow's democracy. It will cover some issues of public governments, of education, of maybe diplomacy, and other public governance fields. So please, the floor and time is yours.
I think
you can use my microphone if you want to.
perfect. Thank you. So thank you for the introduction. That's very kind. And hello, everyone. It's great to be in Vilnius. It's my first time here. Leda and I flew in from London last night. It was an adventure. And it's great to be here to be talking about such an important topic as governance of these technologies, and in particular AI. I wanted to contextualize a little bit our presentation, especially because we're talking about the AI Act. So what we're going to be talking about is how can we ensure that these big businesses that are creating these technologies are incentivized and held accountable for their actions. Obviously, the AI Act goes a certain way to potentially achieving this. And at the same time, I think what we are going to be talking about is how do we implement the principles and more general rules that are in the AI Act in practice, and how can we translate those to be effective? So a little bit of a contextualization there. Before I give you an insight into what we did and how we went about our findings, I wanted to talk to you about our conclusion. So we are finding ourselves in a situation in which I think that the governance of AI at the moment is ineffective, and we need a fundamental shift if we're to be able to reorientate it in the interest of humans, for it to be human-centric, as we're talking about today, and in this context, in the interest of democracy as well. And based on the analysis of the research, which I'll talk to you about in a second, as well as the reflection on our experience and the people that we interviewed, we believe that there's a new form of governance that's necessary to supplement the legal framework that would be implemented in different countries, which we call an AI issue association. And the name is very intentional. I don't know if you're familiar with the concept of trade associations as a advocacy or lobbying organization, which are focused essentially on defending the interests of a particular industry or sector. The idea here is that an issue association would be focused on finding practical solutions to particular challenges associated with wicked issues. We're all, I think, people who have engaged with academic thinking, so wicked issues are probably something that you are familiar with. And I think the important components of such a mode of governance are, firstly, for there to be a strong authoritative mandate that can ensure accountability, for the issues that it's working on to solve to be well framed and concrete enough, for the outputs to be not lofty principles or big picture outcomes, but practical solutions that are translated in the language of, importantly, technologies and the technologists and the companies that are working on these issues, and for there to be procedural openness and visibility so that others who are working in this space can benefit from the learnings and outputs of such organizations. I think most importantly, it's about who is involved in this kind of governance and how the dynamics are modulated. So we believe that it needs to be convened by people who can facilitate and importantly empathize and bring together people with power and passion, people with specialist knowledge, and people with lived experience. I'm talking citizens here. And to facilitate a collaborative approach that importantly modulates the power dynamics between these groups. If we manage to do something like this, I think we have the chance to potentially have technology serve humanity as opposed to just growth and profit, which is currently the focus of the companies that are working on these. I think you'd agree with me, Hubert. So, I'm Lydia. I'm the managing director of Clever Together Future Proof, which is a change agency, as we call it. We work with both public entities as well as private organizations and try to push forward ethical solutions to the big issues that we're talking about. And with me is my colleague Leda, who worked on this research that I'm presenting with you. In addition, we had my colleague Peter Toman participate in the research, as well as Jake Hirsch-Allen, who used to be at LinkedIn and is now involved in AI governance in Canada. The main question we were trying to solve was what is a viable model of AI governance for tomorrow's democracies or for humanity of tomorrow, and how does it work in a real life problem space. I'm gonna briefly introduce our our methodology and key findings, and then I'm gonna actually hand over to Leda to tell you about the concrete application of these findings that we've been starting to push forward in a project. So I think to begin with, one of the things that we need to acknowledge is that we're finding ourselves in a particular context in which we're trying to solve this challenge, which is what we're calling a polycrisis, or coming together of these different crises that are making the context in which we operate harder to navigate and solve for. We have a democratic erosion, which is characterized by low trust in our democratic systems and the proliferation of misinformation in online spaces. We have a technology dominance and big tech companies dominating opinion formation spaces online in particular, and a focus on profit over respecting fundamental rights. And we have arguably a failure to govern these emerging technologies till now. So in order to explore how to navigate this space, what we did is we took a experience-centric approach to our research. And in addition to doing a literature review, we interviewed about 15 people who together have decades of collective experience working on governing new technologies. These people included 10 companies, government representatives, civil society representatives, and the wider private sector, which is a client of these big technologies. And collectively, they shared their standpoint from organizations that reach over 1 billion people around the globe every day. So we feel like what we came up with is relatively representative. The first finding, I think, which is important to acknowledge, is the fact that AI governance of democracy needs to be a multi-stakeholder and well-networked approach. Leda tells me that multi-stakeholder is a dirty word that we shouldn't use because it just, doesn't mean anything anymore. But I think it's important for us to talk about collaborative approaches, right? And what you currently find is, I saw that there was a pointer on here. How do I point? Nope. There we go. Is that collaborative approaches to governance currently only include the purple, actors in the center. But our findings were that we need to widen that circle, and we need to include the pink groups, in particular people like that represent startups, shareholders, and investors that are the main incentive setters for the companies that we're talking about, and importantly, citizens and underrepresented groups that they're currently tokenized in their inputs and in a very consultative manner. I think if we were to zoom out, what we need to be considering is the points of view of those that are affected by the issues that we're talking about and the technologies that we're looking at, those that are setting the incentives for the development, deployment, and use of AI, those who create, use, and monitor the technologies, and importantly, those who write the rules for their governance. Now, the challenge is that there are massive underlying issues that undermine current, AI governance efforts. I think those center predominantly on a big power imbalance that is perceived to exist between the technology sector as a whole and the various groups that are trying to keep them accountable, including governments. And the three main buckets of barriers that we found were, firstly, the fact that there is unhelpful growth incentives and business model that exist for technology companies. And it was felt that most business representatives that we spoke to basically wouldn't agree to participate in collaborative governance unless it aligned with their business objectives and profit approaches. And Leda and I were at a conference yesterday that included a lot of these tech representatives, and they were saying, unless people are given KPIs internally to have a different target than profits, then things aren't going to change in terms of how these technologies are governed and produced internally. The second problem is there's an inability to collaborate and transcend siloed thinking. I think that there's a lot of separate initiatives that are very opaque, that don't talk to each other. There's very little transparency about how these various collaborative approaches are being pushed forward, and in particular, what are the actual outputs and outcomes of these efforts. And there's a lot of kind of groups sitting in their own bubbles, talking to each other about what they believe and not actually sharing points of view and getting to a consensus. And I think finally, and potentially one of the biggest issues is the fact that there's a lack of alternative for what we're calling vulnerable players. And that includes wider business that is dependent on these technology companies for their own business purposes. I'm talking, I don't know, advertisers have 3 social media companies that they can advertise on. Right now, businesses that are trying to leverage Gen AI for productivity and growth have basically 2 companies that they can buy products from, etc. It's citizens who can't move away from these technologies because they depend on them for connectivity with their families, etc. And finally, civil society that sometimes has to be funded by these organizations in order to achieve their objectives. The problem, though, is that under these issues, there's these tensions that we uncovered that I think are very interesting and are driving some of the challenges. So first of all, we're talking about the fact that everyone says, oh, we need binding regulation, but regulation when it comes is very slow, AI Act, and misplaced, doesn't go far enough, et cetera, et cetera. We need to have higher standards, but because regulation isn't coming fast enough, self-regulation is also ineffective. These companies won't do anything on a voluntary basis. We need to ensure accountability, but every time we spoke about, okay, you need to be held accountable to the results that come out of such collaborative governance, that immediately lowered the motivation to commit to any initiative. And we need global consensus, but that's impractical. How are we going to actually, balance between the values and priorities of various cultures, geographies, etc.? We need multi-stakeholder action, they said, but they usually have low impact, visibility, and alignment, and are basically ethics washing exercises. So I spoke to a lot of these people personally, and frankly, a lot of them told me in confidence, Lydia, this is such a great initiative. If you are successful in this, I'm willing to quit my job and come work on this. And I said, why are you going to quit your job when what I want you to do is bring the organization that you're representing in order for us to actually make a difference? And I think there's a challenge that we face here where people have high personal aspirations of this is important, we need to make a difference here, but actually we're not willing to take radical, I want to say, personal responsibility for pushing forward change in the various areas of influence that we have as individuals. So let's move on to the positive side, because I know that we all think that things are doom and gloom and we're not going to get anywhere. But I think that there are certain aspects that we can leverage in order for us to make a difference in this space. Firstly, it's about shifting the incentives that exist. And that means leveraging, importantly, groups like shareholders and investors in this space. Secondly, and we heard the presentation about quantum computing, leveraging the power of governments not just to regulate, but as procurers of these technologies. I mean, the US government is the biggest buyer of technology in the world. If they said that only responsible companies can sell to them, I think that might shift the incentives of how these technologies are produced. We need to boost connectivity between these initiatives. I think we need to rebuild bridges. Civil society right now refuses to talk to the tech sector. And 10 years ago, they were very much collaborating with each other. And we need to pluralize the values. We need to bring in different ways of thinking that are more human-centric. We see some of that in more Eastern cultures and governments that are bringing in AI regulation. We need to bring in citizen points of view. And we potentially, no, not potentially, we definitely need to bring the points of view of the Global South that is serving as a supply chain for this sector that we're trying to keep accountable. I'm going to leave it here. I have no idea how much time I took. Sorry, Leda. So Leda is now going to talk about how we're trying to put these findings into practice.
Right. Okay. So let's get on the more practical side, and I hope I can Yes, it works. Okay, so I'm returning us back to our conclusion that we started with. So this is where the academic exercise usually ends. So we have a research, we've done all the work, we've collected the data, we've done a bunch of interviews, we've done a bunch of research, and we've constructed a model. And we've put people on that model. And this is usually where people go like, yes, amazing, published paper, I am done, I don't care about the impact of this. But we actually do care about the impact of this. So the thing that we did next is we took this model and we put it into a real-life problem space. And a problem space is something that I kind of coined in my mind. And it's something that basically means there's a problem, we've defined a problem, and it occupies a space in society. And this space can be filled with something like this, a model like this. So I'm not going to go too deeply into that because I'm going to tell you more about how we actually implemented and where the different elements of this sit. So when we were doing this, where is the clicker? Okay. So when we were doing this right here in the middle, governance of AI. We were doing it in the governance of AI space because the people that we had around us were speaking on the governance of AI. So our convenience sample in that case was people that had expertise on the governance of AI. But the thing that is good about this model is that it actually works within the governance of technology space, the governance of wicked issues as a whole, and then kind of the governance of corporate capitalism. Or if you want to take it one step further, actually the critique and the dismantling of capitalism and corporate capitalism in particular, if that kind of rings your bell and you're on the Marxist side of things. So here is our little problem space. In August of this year, we collected 9 organizations, and we put together a little Horizon Europe proposal that we called the Nexus Project. And here our problem space is in particular the concept of human-centric digitalization in Europe. So at the very foundation of this is a theoretical framework that is based on, first of all, an expanded view of digital humanism, which takes the humanist tradition from Europe, from the Enlightenment period, and it augments it. So it includes things like women, things like people from the global south, things like other ethnicities, and other viewpoints that are not your typical white, middle-aged male. So what we did as well is we took a very close look of the Digital Decade Policy Program. We heard about this already a little bit, and the Digital Rights and Principles Declaration. And those kind of provided the theoretical framing of how we're dealing with putting our model into this issue space. Then we evolved our issue association model a little bit. And we evolved it in a way that, first of all, includes the issue association as it is, as a multidisciplinary, broad participation network, not multi-stakeholder. And it also includes in it thematic communities of practice. So the communities of practice, each of them have their own topic. They work on that topic. They create knowledge within that topic. And they explore that topic in depth over the course of 30 months. And we also create a hybrid engagement format facilitated through our one-stop shop online platform. So people are meeting in person, but they're also interacting online. There is a repository of knowledge which they help build, they co-create, they co-build together. It sits within that platform, but they also have the opportunity to come together in a physical way and share knowledge in that sort of format. Here are lovely partners. So we partnered with essentially 9 partners from 9 countries. We have 3 universities in the consortium, one standardization organization, which is the Romanian national standardization body, and 4 specialized research organizations and 1 tech company. We also opened the Nexus members network during the preparation of this proposal. So we had 24 Nexus members pre-submission of the proposal, and this network continues to grow today. And we will kindly invite you right at the end to scan a QR code and join the network as well. A little bit about the test verticals. So the test verticals for operationalization go back to our finding that for there to be practical impact, we need to get down to the granular level. So we're not looking at AI governance or digitalization as a kind of a general self-standing topic, but we're going one step below, or even a couple of steps below, and we're looking at particular issues within that general framework that we can help build consensus around, that we can create knowledge around, that we can create then practical recommendations, roadmaps, different types of toolkits, and tooling for the stakeholders that are engaged in this space. And for this one, our mapping showed that we're looking at basic digital skills, AI adoption and AI at work, and the ICT gender gap. Of course, those things are subject to change. There are many other things within the Digital Decade Policy Program, within the declaration, that are important and are seen by the European Union institutions as important. But these are the ones that we've gathered interest in, and we also think that could be impactful in terms of knowledge creation. So the way this works is very simply, the Nexus Issue Association, which is multi-stakeholder, collaborative, open to all, equitable, and it fosters the co-creation of solutions on particular issues, the communities of practice that offer targeted insights, recommendations, roadmaps, and evaluations, and the Nexus horizontal model, which underpins the work of these two kind of bodies or these two structures in an end-to-end self-reinforcing process. This is briefly what it looks like. So it takes into consideration these types of inputs, and then it ends up with these types of outputs after we've gone through the process. And here are some examples of what we're promising. So here is our kind of idea of multi-stakeholder alignment within 40+ countries that we're promising. So there's the diplomatic aspect of this as well, and the cross-country governance aspect of this as well. There is the aspect of education, because we're looking at 300 stakeholders with increased awareness and 100 stakeholders with better skill sets. And then on the expected outcomes, you can see that we're actually building something that can be then plugged in into other problem spaces and activated just as easily. So this is it from us. We do urge you to, first of all, contact us and download our presentation, and also join the Nexus Issue Association today. Thank you.
Thank you very much, ladies, for indeed interesting presentation, including theoretical part and practical part, and example of a Nexus project that will be, I hope, I'm sure, during the coffee break you will get a lot of questions from the audience. We have two presentations, two professors, and first of all, I would like to invite research professor Grozdanovsky, Tube. He's from Belgium, from Liège University, and he will present us the rights to explanation in different EU legal norms. Shortly, we are very glad to have you here in Vilnius. I don't know if the first time or the first time. So he's specializing in the field of EU law, have different degrees and awards in European studies at different universities. Now in Belgium, the main research place. The title of doctoral dissertation was Presumption in EU Law, with summa cum laude. I'm glad to have you in our conference. Please, the time and floor is yours.
Thank you. If you don't mind, I'm going to use that. And
I think you have to come out of the file.
yeah. Yes, go ahead. I press here to change, yes. Okay. So thank you, Madam Vice Dean. Thank you to the organizers. It's such a pleasure to be here in this illustrious panel and this illustrious university. So today I'm going to talk about various provisions that grant the right to explanation in connection to discrimination cases or AI-related discrimination cases. Now, probably most of you, what you're thinking is, does the world need yet another study on AI discrimination? Because so much has already been said, and yesterday we were talking about, biases and risk of biases, and the bias has really become like the go-to topical example of what can go wrong with AI, right? But as in Liège, I coordinate the Just AI Jamone Center of Excellence, and what we're interested in is procedural fairness, and that's my area of expertise. So I work on evidence and access to evidence, meaning when you are a victim of harm that is associated or occasioned by AI use, which evidence should you adduce before a court in order to get compensation of that harm? And discrimination is an interesting example. This is a topic that I've been working on for the past few years, and it really started, I'm sure most of you are familiar with this, it really started with Amazon's recruitment algorithm. I mean, I'm guessing most of you are familiar with that. Amazon created an algorithm, and then the algorithm shortlisted candidates, and it turned out it shortlisted only male candidates. Amazon freaked out. They were like, well, how come this happened? And so they reverse engineered the decision, and they figured out that the algorithm actually referred to the historical data, so the recruitment practices of Amazon over a period of 30 years, and it turned out that Amazon itself had a tendency of recruiting men, unfortunately. But, so this is a case of a provider of a recruitment system uses itself or deploys the same system and figures out that there's something wrong with the system's output, right? But if we in this room at some point are applying for a job and our CVs are automatically processed by a recruitment algorithm, how would you know that you're discriminated against? That's the question. So, am I pressing? Yes. Okay. So I wanted to start with three cases, topical cases in my mind. There are many, as probably most of you are aware, AI liability litigation is on the rise worldwide. The most telling examples, I think, are in North America right now, but there are some European cases that start to emerge. The first case is a Sao Paulo civil case. It essentially deals with an AI biometric identification artificial system that was used for public surveillance in the Sao Paulo metro. And the claim that was brought before the tribunal was, well, the system is trained on two genders, men and women, so there's a risk of discrimination of non-gender conforming individuals, And by the way, I think the tribunal said, yes, indeed, there is a risk of discrimination, okay? The second case, I'm sure the lawyers in the room are familiar with this case, the Loomis, it has become really kind of emblematic, right, of AI litigation. So Compass, the Minnesota courts used Compass to predict the risk of recidivism. The case went to the Wisconsin Supreme Court, and the Supreme Court found that no, there was no risk of discrimination because the defendant, the accused, actually said, well, Compass is more likely to predict recidivism when the accused are men and belong to ethnic minorities, right? But again, this was the argument, but the Supreme Court of Wisconsin said, no, 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 it's a tool. The ruling of the first-degree courts of the lower courts would have been the same had they not used Compass, which is debatable, but anyway. And finally, Pickett. Pickett, for me, is a very, very interesting case. Again, New Jersey police authorities used a DNA testing artificial system to track down, identify, and arrest a person that was involved, allegedly, in a public shooting. The person was indeed arrested, and the first thing that they said in their defense was, the outcome is inaccurate because it is biased. You know, so they also argued gender discrimination. Now, I mean, I'm not going to go into the detail. We can, of course, discuss about these cases at some point during the break or if there's time for the discussion. But what these cases have in common is that they all deal with a risk of discrimination. No bias was proven in any of them. Take the Sao Paulo case. The claim was, given the data that was used to train the system will probably discriminate against non-gender conforming individuals. But there was no non-gender conforming individual who actually went before a court and said, I'm discriminated against. So let's see what we can do here, you know, to compensate the harm that I suffered. Same thing in Loomis, same thing in Pickett. The accused were not certain that they were discriminated against. It was just an argument that they brought forth before the courts to say the output that concerns me is inaccurate because there's a bias that targets me. I don't know whether there is a bias, but I need access to evidence in order to figure out whether such a bias exists. Hence the question, you know, what happens with the procedural rights of people who are subject to automated decisions and have the suspicion, founded or not, that they have suffered some type of harm. Now, when I say harm, I mean the subtler forms of fundamental rights violations, right? There are forms of harm, like harm to health or safety, that are more tangible, that are more discernible, right? And there's also case law to support this. But, and I will also present later today another presentation that I co-authored with a couple of engineers. There are forms of harm and forms of biases that are not blatant, that are not obvious straightforwardly. And in order to figure out whether there was a discrimination or not, well, you need evidence, okay? So what I did was, I will be kind of brief. I'm trying to be expedient. Yeah. What I did was I looked at the principles that roughly govern the access to and administration of evidence in discrimination cases in EU law. And there are roughly two principles. I'm not going to go into the detail of this, but we may, of course, for those of you who are interested, we may pursue our discussion. The first principle is that biases are in principle known or can be known. And this is in particular the case with indirect discrimination cases. If you have been subject to a treatment that you consider to be unequal treatment when you compare yourself to persons in comparable situations, then you might plausibly argue that there is some form of discrimination, right? You're a woman, you compare your salary to your male colleagues, you realize that your salary is lower. And so, you know, for similar or identical work tasks. And that is a hint to gender discrimination, right? What is interesting from a procedural point of view is that in 1989, the European Court of Justice, this is a Dampos case, and coincidentally does deal with gender discrimination in terms of salary. In Dampos, the European Court of Justice said that when a victim has a founded suspicion of being discriminated against, the defendant, so the perpetrator, if you will, of the responsible person of the discrimination, should make their evidence transparent, right? So the victim, the alleged victim, should be able to go before the defendant and say, please give me the information that I need in order to launch an action of discrimination against you, as it were. And so, but the point of downforce is that the defendant should not obstruct the access to evidence. You know, the access should be possible or should be feasible. And that's the second principle. So the evidence of biases is accessible or should be accessible to victims. A notable exception is the Meister case, which deals specifically with the case of recruitment, but I'm not necessarily going to delve into that because, again, expediency. What I'm interested in, you know, so discrimination, as it is, can be challenging to prove. But when you add artificial intelligence in the mix, it becomes even more challenging, especially from a procedural point of view, especially from the access to evidence point of view. Luckily, we have a variety of provisions that now recognize the right to request an explanation, right? So first, there's Article 22 of the GDPR, and the emerging cases, Schufa from the recent case from the European Court of Justice, and a pending case done. We have Advocate General de la Tour's opinion, both cases useless when it comes to clarifying the scope of Article 22 GDPR, personal opinion, but you know, please correct me if I'm wrong. So for personal data processing, Article 22, right to a human explanation. Of course, Article 86 of the AI Act, right to a human explanation, but a different kind of explanation. I will get to that. And in the future, the right to request access to evidence under Articles 3 of the AI Liability Directive and 8 of the revised Product Liability Directive. So we have all of these provisions that one way or another deal with automated data processing that recognize essentially variations of the same right, meaning the entitlement of a person to go before an entity and request an explanation of what happened, basically. So the question is, will any of these provisions open up the access to the knowledge of biases that will allow people to assess whether they should go before a court or not? And here you can see there's the lex specialis issue. Well, if I want to launch an action of non-discrimination and I need an explanation, which provision should I rely on to receive that explanation, right? Because potentially several of these provisions can apply together or individually or not apply at all, right? So the first application, possibly joint application that I will talk about is Article 86 of the AI Act and Article 22 of the GDPR. Of course, this joint application, possible joint application between these two provisions only makes sense when there's personal data processing, right? Which a recruitment scenario is a typical example of that. You have applied for a job, the recruiter informs you that they're gonna run your CV through a recruitment system, you say yes. In other words, you consent to your personal data being automatically processed, right? So, but after the recruitment, the recruiter calls you back, says, I'm so sorry, we're not gonna call you for an interview, and you suspect that there's something fishy about that. So you need an explanation, and the question is, which provision can you rely on to receive that explanation? So Article 22 is a curious beast, because if you look at the conditions for application, they are quite vague. So first of all, this article applies in the presence of fully automated decisions. Nobody really knows what fully automated decisions are. Article 22, the Article 29, sorry, Working Party said, well, those are decisions that are made through automated means and also decisions that are automatically relied upon by the humans, using those automated means. Okay. We could have, or the Court of Justice, this is why I was critical of the recent case law pertaining to Article 22. The Court of Justice could have clarified what fully automated decision means in the Shufa case, for example, but it did not, or it did not sufficiently. The Advocate General kind of said, well, if the means are automated, then okay, we can apply Article 22, but still, not very enlightening. And the second condition for application is that the decision should have legal or significantly similar effects on a person's situation, which again, what is that? Because if I, again, to take the recruitment scenario, if I want to know if I was discriminated against, in other words, if I wanted to know whether my legal situation was affected, I would have to have access to information, which is why I want to rely on Article 22. But for Article 22 to apply, I have to prove that my situation was, so anyway. So you see, it can get a little bit convoluted. But if we assume that Article 22 does apply in a given situation, let's assume that a person has met the conditions for application, then they get to receive what scholarship has called the human explanation. Again, nobody knows what the human explanation is. Nobody knows, if you look at the Article 29 Working Party, and also if you look at the Advocate General's opinion, Advocate General de la Tour's opinion in the Dunn case, they focus on the format of the explanation. So the explanation should be clear, understandable, basically vulgarize, the output or the outcome of a given situation where an AI was used. But there again, scholarship was more enlightening. Wachter, Floridi, and Mittelstadt seminally back in 2017 said that basically the explanation that is due under Article 22 GDPR is an explanation about the system that is used. And so they said, well, there's ad hoc and post hoc dimensions. Ad hoc explanations include explanations about the functionalities of the system, so what the system can do, its intended purpose, and post hoc, the explanation should provide understanding on the rationale of the output. So, it's, but the takeaway from this kind of debate on what the scope of the explanation under the GDPR is that it is an explanation that really pertains to the system and what the system does or can do, which contrasts with the type of explanation that can be provided under Article 86 AI Act. So here again, the conditions for application are vague or stringent. Article 86 can apply only when the explainer is a deployer of a high-risk system. There should be a human decision that is based on AI output. Again, the decision should produce a legal or similarly significant effect on a person's situation, whatever that is. And that decision should have an impact on health, safety, and/or fundamental rights, which, again, we're talking about, or I'm talking about, types of harm that are not straightforwardly discernible. So, the significant effect part and the impact on fundamental rights part can raise a few eyebrows in terms of, the proving the conditions for application of Article 86. But assuming that the conditions are met, then the explainee should receive a clear and meaningful explanation on the role of the AI system in the decision-making procedure and the main elements of the decision taken. In other words, the decision that you receive under Article 86, the explanation that you receive, is an explanation of the human decision. So it's a statement of reasons from the deployer having deployed an AI system. And remember, I kind of emphasized the point on Article 22 GDPR. This is an explanation about the system, and this is an explanation about the human having used the system. So, yes, I'll step on it. Sorry. Do I get 2 to 3 minutes more? 2? Oh, God. Okay. So, the following four-ish slides, I mean, you know, it's going to be interesting. I hope I can explain myself apropos this right to explanation. So anyway, is Article 86 a lex specialis to Article 22? In other words, in discrimination cases, if I want to know if I was discriminated against, would I rely on Article 86 rather than Article 22 GDPR? And the answer, according to me, is perhaps, provided that the defendant is a deployer of a high-risk system, and provided, again, that the data processing, that the processing concerns personal data. Okay? Why? And I wouldn't be surprised if in future, in the upcoming years, there's a strategic litigation that develops around Article 86 and Article 22, because again, the explanation that I can access based on Article 86 is the explanation of the human decision, which is always much easier to kind of acquire, right? Under Article 22 of the GDPR, presumably, they would, in order for me to receive the explanation of what the system did, they would have to be reverse engineering, so much more arduous. Article 86 seems much more feasible. Very quickly, in the future, we will have the Air Liability Directive and the revised Product Liability Directive. Both include a right to request access to evidence. So how does Article 86 AI Act and the Air Liability Directive apply together or not? Well, not going to get into the detail or the nitty-gritty of both directive proposals, but the Air Liability Directive demands that the victims of harm undertake preliminary steps, go seek the information from the defendant gives them the information or not, and if they don't, the victim can go before a court. And in that preliminary seeking of information, that's where Article 86 can come in handy. Because Article 86, nothing in Article 86 of the AI Act specifies that it is a provision that should apply in court proceedings only, right? So Article 86 can apply whenever a high-risk system is deployed. Whenever such deployment is there, you can request for an explanation, and that explanation is due. And so based on the information that you receive on the basis of Article 86, you can then assess the need to go before a court and launch a proceeding on the basis of the Air Liability Directive. So in that sense, I hope this makes sense. I'm going very quickly. But Article 86 may be an antechamber to Article 3 of the Air Liability Directive, in a sense that first you receive an explanation based on the AI Act, and then you launch an action based on the Air Liability Directive. And finally, the revised Product Liability Directive. I don't think that the AI Act or Article 6 of the AI Act will apply jointly with the revised Product Liability Directive, simply because discrimination is not one of the harms that is covered by the revised Product Liability Directive. You know, I'm not saying that biases are not connected to any of these harms, but if you want to really bring an action of discrimination, the revised Product Liability Directive would not be the instrument that you would consider. So, how do we navigate the pantheon of the rights to explanation? Well, it's nice that they're there. It's lovely. It's really coherent with the ethos of the European Union, Les Verts, and so on, where the European Court of Justice said, well, there has to be a choice of remedies. There has to be a plurality, a multitude of procedural entitlements that private parties can exercise and can access based on EU law. However, if we look at the conditions for application of each of these provisions, some might be stringent, some might not be as realistic. So we might raise the question of the effectiveness of these procedural entitlements. So it's nice that they're there. It's nice that there are several vantage points or access points to explanations, but the feasibility and the conditions to exercise these entitlements, for me, remain an open question, and I think we need future court practice to clarify that. I have probably went over the time limit, and I apologize for that. But I will stop here and look forward to any questions if you have, questions to ask. Yeah.
Thank you very much. Thank you very much. You made a long journey, a long legal journey, but we tried to achieve the procedural justice. And to answer the first question you raised at the beginning of your presentation, the question of risk of discrimination. But there are more questions, like ethical question or basic question rising in the area of IA implementation. And our last presentation in this panel will deal with 3 additional ethical questions. Perhaps the discrimination question will be included, but we will see. Professor Dr. Hubert Etienne from France, from Po Science University, will present us the topic on 3 ethical questions at the age of generative AI. You don't need to provide us an answer, just a question. And the answer will be provided by the judges and the public authorities, because we have in this audience a lot of people from Lithuanian legal authorities, from courts, and very glad to hear this question and to raise this question. So please, the floor is yours. And 3 questions still waiting.
Good morning, everyone. Vice Dean Deringa, thank you very much for the invitation. Can you hear me well? Yes. Okay, I won't keep you too long before the break, I swear. But so, as you said, I teach AI ethics. I also used to supervise the ethical development of generative AI product at Meta. So that's why I apologize. My slide will be a bit Facebook-styled. And I'm also a philosopher, so sorry, I will preach for my own church today, in front of you, many lawyers today. I'll preach for philosophy. So we talked about this one, famous Loomis case, the compass case, as we call it in philosophy. I know it's your case, not our case, but that's how we call it, because of the name of the algorithm that was involved in that. I won't come back over this, because I want to address 3 main questions today that we have to address also for the industry in AI ethics. And why am I mentioning this one? Because it was pretty much the first time we asked philosophers to get involved. Why so? Because technical people couldn't bring an answer to a technical question. So 2013, we have this case, which everyone is very familiar with, I hope. And what is interesting in this case is that we had ProPublica, a think tank in the US, saying the algorithm is biased. We did the audits based on a lot of court decisions in the US, and we have a bias against black people. You have the reference here. It was by Angwin. And they said, I'm quoting here, black are almost twice as likely as white to be labeled as higher risk, but not actually re-offend. So that's the result of the assessment they had. More interestingly even, we had a second assessment, if it moves, from the Kleinberg team at Cornell University. 3 researchers conducted a counter-assessment of the algorithm, and they realized it was a bit more complex than what we initially thought. We cannot just say, okay, it's biased against black people. It actually involved different kind of metrics we use to know whether the algorithm is fair or not fair, it's biased or unbiased. And I won't go in the technicalities of it today, but just remember that there's 2 metrics intention here, and the conclusion they had is that first, inherent trade-off in the fair determination of risk score are involved. You cannot have both at the same time. So the algorithm was well calibrated between groups, but badly balanced between classes. So two different kind of metrics we use. And they said we cannot have both at the same time. So we need to make a decision. And they came up with what we now call the Kleinberg impossibility theorem, that you cannot have both at the same time. What does it mean for us? It means that the technical people cannot get a technical decision to a technical problem. So they said, let's call other people, let's call philosophers. Boom, we open the door and say, philosophers, come in. We need another discipline to help us figure out what to do with that. But the problem is that they closed the door pretty soon also, because they understood what philosophers do. They come, they ask a lot of questions, they have no idea how to answer, and that's bad for the business and everyone. So, you know, I give you a quick chronology of how I perceived this evolution of questions. So that was 2016, roughly. Also the beginning of deepfakes, for those who know. And in 2018, everything was open. Everything was open. We were asking the big question, what does it mean to live in a world with AI? How do we build better societies and everything? Quickly, let's go back to business questions. I think you addressed it very beautifully. And so we realized we had this weird object we need to define called AI ethics. And what do we do with that? How do we train people to need technical background, philosophical background, law backgrounds? Who's going to address this? Which kind of question should be addressed? And who's going to pay for that? So that was a big question at the beginning, and mostly it was developed in some big tech companies. At that time, when I was still at Meta, there were 6 people addressing this question. 3 years later, there were more than 198 AI engineers, and we were 2 philosophers. And there were also a lot of legal people. So that was in the 2018. We had what we used to call AI ethics. We don't call it anymore this way, unfortunately. But around 2020, we moved towards a set of questions much more narrowed, which are responsible AI, which are most of the questions we talk about today, around biases, explainability, robustness, transparency. And I was a bit surprised at that time, because I thought when we had all this code of ethics, you know, ethics comes from philosophy, it's moral philosophy. And I said we have all these principles, but they're not really philosophical principles, besides fairness, which is an important one for us in philosophy. The others were not really much of that, because we're going through the regulation of AI. So it was like the antechamber, to reuse a word I just saw, of the regulation coming. 2020. And 2023, in between, we had something called trustworthy AI somewhere. And then we had something called trust and safety. That's what we have today. And we put all the questions in the same box, you know, questions around content moderation, misinformation, hate speech, mental health, everything in the same box. And we say, this is what company will address. I think this is a bit of a pity, because you have a trade-off as everything. So we have a regulation now, and we have a beautiful presentation of the AI Act and other regulation, and we saw all the difficulties of actually implementing this. But you know, the more constrained it becomes, also the narrower the questions. We're going to have it everything in the same time. But for philosophers, we got a bit disappointed, because of course the scope of questions we can address today is much more narrow than it could have been. It's a lot about safety questions, which are pretty much the component you ask for any technical tool or good you develop, right? It's nothing new under the sun. So we tell you that AI is going to change everything. You hear in many conferences. But the kind of questions we ask are not about which kind of society we want to live in, what does it mean to live in a world of AI. It's just about, okay, let's have a risk-based approach. Let's try to develop AI, reduce all the constraints around this, and avoid to have too many bad stuff happening. So I think we need to reopen this a bit. How do we preserve ethics? So I told you we need to preserve it, I think, from safety concerns on the one hand. We also need to preserve it, so I'm not going to make friends today, regulatory concerns. Which I mean by this, of course, not that we should not have AI regulation, obviously. My point here is that this is the first step, obviously, but it should not be the only step. We should still keep asking the question around ethics, because it's way too important. So I'm sure everybody is familiar with that, but just to remind it, law and ethics, we have a lot of connections together, but the two disciplines are also a bit autonomous. Ethics sometimes comes before law. That was the case in the European Union with the Ethics Guideline for Trustworthy AI. A lot of people, some of them with law background, others with philosophical background, others with technical backgrounds, what we call a multi-stakeholder panel, decided for a set of ethical principles that eventually became part of the AI Act. It was the first reflection around this. So ethics can come before law. In France, we have the revision of bioethics law every 5 years. And again, you have an ethics committee, few philosophers, not all of them, but the question is, what is ethics and what is society willing today? And we revise the law often. So sometimes it comes before, sometimes it comes after also, you know, when everybody knows what, supposed to know what the law says, and you decide as an individual whether you want to abide by it or not on every situation. And sometimes it goes aside the law also for things that the law is not entitled to regulate. Classic example, cheating on your wife or husband. Yeah, I don't know for every country, but most countries it's something unethical but not illegal. So ethics is also, you know, a normative system that goes beyond the other one. And the third thing from which we want to preserve ethics, and maybe we can all agree on this one, is on the attempt to automate ethics. So probably some of you have seen the MIT moral dilemma around the autonomous vehicles. I focused on this one a lot, and the problem with this one, I'm not going to talk about all the methodological problem behind this, just one is that they collected a lot of data, asked people to answer questions around the ethics of autonomous vehicles, and then when they had like 40 million answers, they just use it to train an algorithm, a consensus algorithm, and say, this is what people say. We have a lot of people who answer the question, so it's kind of objectivity coming from it, like an intersubjectivity. We build the data sets, we train the algorithm, we can use it in autonomous vehicles. A lot of issue with that. But just one example of engineers, I hope we don't have that many today, saying, oh, you know, this dilemma philosophers have been debating for years, we don't care about that because we can actually deal with it in an algorithmic way. I think this is extremely important and extremely dangerous because it's one attempt to do it. It was called the voting-based system. There are many others. I give you a Delphi example, but there are many, many others trying to say, why do we need ethics? We just survey a bunch of people and then we build a consensus algorithm. No. First of all, because there's always a lot of limitations in the way to do it, but there are smartest way to do it. But even if you do it, you know, ethics is about the process, it's about who's speaking. There are some parts of ethics where people consider like naturalism, they consider there's some ethics that is true, the rest is not true. But in the way we work as societies and democracies, there's a legitimacy process that needs to be respected. And whatever the algorithm may say, it may just be wrong or right just because of the process itself. So the most important here is, I think, to preserve more agency and responsibility in the process. And so try to avoid automating the ethical decision making. The second issue I want to discuss today is about the bias issue, again, that we've been talking about a lot already. What I want to say on this is that we have different definitions of biases. If you look in statistics and sociology, we have a very clear definition of what a bias is. It's an observation bias. So it's a predictable gap between what you observe and what you think you should observe. So taking a very simple example, if I have blue glasses, I will see this table, and I know that the glasses are blue, so I will sit in blue, but probably it's another color. And so knowing that, you know, I can retrain, I can adjust my results. That's something we have in sociology, in statistics, in science, roughly. The way we address it in algorithmic decision making is a bit different because it got political. So, you know, the three main protected categories you have here, men, women, black versus white people, gay versus straight people, comes from the US. Comes from a US population because most of the people who focused on this initially were American scientists. And so they set up the standards for the whole world pretty much. But, you know, yeah, I would tell you, when I was at Meta, like 50% of my time I was fighting just to say, you know, we have other issues in other countries. So that matters for you in the US, but for instance, where I come from in France, and maybe we can generalize that to Europe, we also care about poor and rich people. That's something that has been driving, you know, our political scene for years, and that matters more than some others here. I'm not going to say which one matters most, but like it's been mattering for a long time. So we want to address that also, and it means that we need to fine-tune models from a country to another because we don't have the same issues. And if you just focus on the issue of one country, you will bring the same issues in yours. Again, I'm not saying we don't have issues of this kind in every country. I'm just saying that we should fine-tune it by country because the context and the population changes. And that's one big issue, and that's few companies are actually doing this today. A second problem we have here is about the confusion around biases. So I said we have clear definition in statistics, in science, about biases. Then came algorithmic biases, and if we can push it, actually, I could show you that biases don't really exist in models, just every single decision is based on the bias. I don't have time to explain, you would not trust me, but trust maybe Yann Lequin, who was saying that 2 weeks ago in France, everything is based on biases. This is how we make decisions, and then at the end of the day, once you solve the science around this and you did a good job, it's about what are the decisions we want to allow and not allow. It's a political and moral decision, it's not a scientific decision. Sorry, philosophy is science. It's not a technical decision, let's say. The third one is by cognitive biases. For instance, right now it's getting close to noon. We all are impacted by tiredness, probably you more than me right now. And so we know that cognitive biases impact the way we make decisions. We have the statu quo happening right now. For instance, if you have to make decisions, you will tend to take the safer decision right now because it was well documented. So statistical biases, algorithmic biases, cognitive biases, they all respond to different kind of processes. And they should not be put together. So you had an article recent, a couple of years ago saying human bias are harder to solve than algorithmic biases. And the narrative you had behind this is just to say humans are biased and we need to correct humans just like the way we correct machines. We need to de-bias human beings. And if you follow that narrative by people just saying bias is the evil, you know, we want to remove every bias, whatever bias we're talking about. Then you put everything in the same buckets. And when you look, especially in the literature from transhumanist movements, who are the people doing that a lot, they consider as bias sexual preferences, political opinions, religious opinions. A lot of things, pretty much everything that makes you singular as a human being, they consider it to be a bias first, because it derives, makes you deviate from the perfect, autonomous, rational agent you should be. So putting that all together, the kind of agenda they're having is just to say, we want to remove every bias because we want people to be like machine, making rational decisions, becoming rational agents. But the proper of a rational agent is it's amoral. It's not immoral, it's not moral, it's amoral. It doesn't care about morality. So it doesn't live in a society. It just coordinates as agents. And the third question, hope I'm not taking too much time.
No, it's okay. It's okay.
I swear I would go quickly. So the third question is coming with generative AI, especially, because the other one we had done before, but like it's even more important today with generative AI. This one is very proper to generative AI. So when you generate, here you have a model, I think it comes from DALL-E 2. When you have a text-to-image model, why do we have 4 outputs? These standards were set up by OpenAI initially, and pretty much all models are doing that. Why 4? Because you need to be able to balance between 2 men, 2 women, 2 gay people, 2 straight people, and 2 black people, 2 white people, and then you can, arrange a bit. That leads to a lot of questions. First question, okay, fair. We balance representation, but how do you represent a gay person versus a straight person? And avoiding stereotypical representations, of course. Then it gets harder. Then you start asking the question you don't want to ask because it delays a lot, by a long time, the shipment of the products. Second question, you need to fine-tune, as I told you, these categories are protected categories in the American and the US literature, scientific literature and regulation, but it should be adapted by every country. It's just like when you train an algorithm, a vision algorithm, to detect images. And in the US, we would pay attention, like black people would be considered as a minority, so you need to take that into consideration. If you take the same model and you deploy it on the population in Ivory Coast, I didn't check recently, but probably 90% of people are black, 10% are other colors, and so the majority changes, and so your accuracy of the model changes. So at the end of the day, it's just about just being, I would not even say smart, but just having common sense on like what the algorithm was trained on in terms of data and the population it's supposed to apply to. And that comes even before asking the ethical questions. But when you do that, so you have what we have here is a question of representation. And the two main, let's say, schools around this are people one side say, we need to represent the population as it is. If we have 60% white people, 40% black people, this is what we should apply here. And then you keep going. But then, okay, that means that we need to collect data to know if people are black or white, if people are homosexual or heterosexual, if people are poor or rich, and so on. How do you represent a rich person versus a poor person without stereotypes, and so on. So what does matter? What are the differences that make a difference? If I may take this sentence from Bateson. How do you represent them? How do we collect the data? In some countries, I don't know from here, but you will tell me, but in France, for instance, we're going to have ethnic statistics for historical reasons because Second World War. So when you collect data to actually train this algorithm to represent the population the way it should be represented, then you have a privacy issue and also going with the data leaks possibility. Other people, on the other hand, say we should not represent society as it is, but as it should be. And so if you have maybe, again, sorry about statistics, I didn't check this one, but 1% of non-binary people, they should be represented like 10% instead of 1%. So again, another question, fair enough, we get the reasoning, but should be 10%, 20%, 30%, and it comes back also to the question, how do you represent a non-binary person? So all these questions need to be addressed here, and it led to some classic scandal you've seen recently on Gemini. So this one, the first one you see was, sure, here's an image of a pope. We never had a pope who was a woman, and we never had a black pope today. Maybe it will come, maybe it won't, but it was a big scandal recently. Why? Because it's what we call hallucination here. The second one is maybe more important because on the first one, it could become true. On the second one, it was about the fathers of, the founding fathers of America, and none of them were black. So this one cannot become true. And beyond the scandal on this one, because people love scandal, but the real question, again, is about the representation. That's the question that matters today. And I will just conclude with one bad word coming from sociology and call it self-transcendence of the social, which is just the fact of impacting people's behavior by the representation of themselves you give them to see. It's like a mirror you give to people. We used to call it the mirror of the king, just to know what is my population, what does it look like. And it's just like when you have students, and if you have 20 students in a class, you tell everyone, here's your grade, this is the best grade of the class. Don't tell the others. They will probably be encouraged, and like maybe some of them will, go to a PhD and become academics, or to another career maybe if they want to. But they will be reinforced in, I'm a valuable person versus the other. If you tell everyone this is the lowest grade of the class, you may have the opposite reaction. So I won't engage too much into that literature, but there's a lot on this. And the whole question is about, so these examples, if you take it from Meta, for instance, when you have 4 billion people using your services or other companies, small changes in the way you represent the population and people can situate vis-a-vis the population is a huge change for society. Thank you very much.
Thank you indeed for such an exciting presentation. We need always to keep in mind that ethic, like quasi-normative order, is around us, around legal order. And sometimes we, as a lawyer, we think that we are alone in this world, and only we are dealing with AI, but it is wrong. the question is important for different disciplines. And I'm very glad that we had your presentation, such an interdisciplinary approach. Now I have one good message for you and for me too. We will have now the coffee break, but the coffee break, if I may say, it could be much more longer as 15 minutes, because we don't have a discussion. And we can continue our discussion during the coffee break. Thank you very much, really, in this panel, for all speakers, for your inspiring presentation, inspiring speeches. I think you touched us, you touched the audience. And now, kind of invitation to join the coffee break and to continue discussion on all the questions flowing now in this area. So thank you very much for everybody. So we will start at 12 o'clock or a little bit, 10 before.
15 minutes coffee break.
Oh, so hot. 11:45. Okay, so good message corrected.